Today, I'm going to be talking about Wendi. She was the subject of a bitter divorce, a murder for hire, the Adelsons versus FUS law professor Dan Markel, a family divided, a father gone, 4 trials, Wendi the ex-wife testifying, 5 convictions, including Wendi's brother Charlie, and now her mother Donna. Will one last domino fall, or will Wendi Adelson's immunity deal get in the way? Prof. Joe says no. Ciao a tutti. That's the Italian for hi. I am Prof. Joe, the law professor, and this is Prof. Joe Explains, where we're going to be talking about all things law. I am really happy that you're with me today, so welcome. Today, I do want to look at the immunity deal with regard to Wendi, but I want to start just to give a little review of the Dan Markel murder and the ensuing trials and the cast of characters. I am virtually certain that most of you who are listening know this case very well, but there may be a few new people for whom a little information might be helpful, and so it's addressed at them. It was a 2014 murder for hire. Dan Markel was a Florida State law professor. He was married to Wendi Adelson. The marriage went sour, and of the cast of characters, Sigfredo Garcia was the person who actually pulled the trigger and was the person who did the physical act that killed Dan Markel. Luis Rivera, a friend of Sigfredo's, drove the car. Catherine Magbanua was the longtime girlfriend of Sigfredo Garcia. She also was the girlfriend at the time of the murder of Charlie Adelson. Charlie Adelson is Wendi's brother. Wendi's mother is Donna Adelson, and all of the people I mentioned, with the exception of Wendi, have been convicted of murder now. Donna most recently in 2025. The messy divorce, and it was pretty acrimonious. The issue that really got the Adelsons manic, I would say, was the location of the 2 boys, the 2 little boys who were the sons of Wendi and Dan Markel. Wendi really wanted to move back to Miami, where her mother and father lived. Wendi's mother, Donna, was desperate to have her 2 grandsons back in Miami. They tried to get the judge at the custody hearing to agree that Donna could move. The judge said no. Dan Markel would not agree. He was, from anybody you hear about it, a wonderful father. He wanted direct and really deep, continuous interaction with his boys, and he wasn't about to have them live 8 or 9 hours away. He said no. He was in the way. Once the judge said that the judge was not going to allow Wendi to move with the boys, the murder plot was hatched. And in 2014, Dan Markel was killed. Wendi Adelson, who now, at least for social purposes, calls herself Jill Estrada, testified in all of the trials. She had what's called a use immunity for the testimony. And let's look at slide 1 now. This is the 5th Amendment, because I want to start with the 5th Amendment privilege so that you can have an idea of what this immunity relates to. So if we can see the 5th Amendment, there you go, it's up. And as you can see, the important part of the 5th Amendment, which I've got highlighted, is that no person can be compelled to be a witness against himself. That's the Fifth Amendment protection that says you do not have to provide information to the police if you think it might incriminate you. Now, there are 4 important elements to getting the privilege against self-incrimination. There are 2 important elements to having the privilege at all. First, the privilege applies to testimonial information, in other words, words. So fingerprints are incriminating. Fingerprints might be enough to get you convicted of a crime, but fingerprints are not words. They don't come within the umbrella protection of the Fifth Amendment. The privilege only covers information that might tend to incriminate you. If you might lose your job over it, that's not covered by the privilege. If your spouse might divorce you because of it, that's not covered by the privilege. What it covers is incriminating information that comes in the form of words. Now, words can be in-court testimony, and that is what happened with Wendi Adelson, but they don't have to be in-court testimony. They can be out of court, talking to Detective Isom, the police officer, the day that Dan Markel was shot. Might be covered by the privilege. Certainly it meets the first element, it's words. Telephone conversations, text messages. Wendi wrote a book. All of those things are words. They all meet the first element of the privilege. You can sing in a song and it would be covered by the privilege. As long as it's words, you meet the first element of the privilege. Wendi spoke a lot and spoke to others in addition to writing that book. She spoke to Jeff Lacoste, who testified at the trials. She spoke to the TV repairman, who came, as you recall, the day of the murder to fix a TV that couldn't be fixed. She spoke to her friend Sarah Youssef, who so far has not testified at any of the trials, but when and if Wendi is prosecuted, I think she will testify. And of course, Wendi spoke to Detective Craig Isom the day of the shooting for maybe 4.5 or 5 hours. So she's got words, and words are covered. But the second element is the words have to be incriminating. They don't have to be, I did the crime. You can have a string of inferences that have to be connected in order for those words to matter. But the string of inferences is enough. The privilege covers anything that might tend to incriminate you. So that's element 2. Now, the third part of the privilege requires that the information you provide is compelled. If you voluntarily talk to someone, you have no Fifth Amendment privilege. You voluntarily write a book, no privilege with regard to the book. You send 100 text messages all on your own, no privilege. It has to be compelled. Now, if a police officer came up to you, put a gun to your head and said, your testimony or your life, that would be compelled. Now, of course, a police officer isn't about to do it. That would be a problem for a lot of other reasons, but it would be compelled. Being subpoenaed to testify at a trial is compelled testimony. So for purposes of Wendi's testimony at the trial, so far, it's words. Some of the words might tend to incriminate her. They're incriminating. The fourth part of it is that it has to be the government that's doing the compelling. And of course, it's the state prosecutor who's forced Wendi to come to testify. All 4 of those elements, if they're met, give somebody who's going to testify the right to say, I won't talk, and to hold the privilege up, the Fifth Amendment up in front of them. I won't talk because it might tend to incriminate me, and you've got an absolute right to do that. That's where immunity comes in, because a grant of immunity says, okay, we understand that you cannot be compelled to give testimony that might tend to incriminate you, but we're going to give you immunity. And once we do that, that testimony cannot be used against you. You can no longer waive your privilege as a shield. You can no longer protect yourself from having to testify at a trial. So again, government forcing you, incriminating yourself in words. Now, the fact that I say what I might testify to might tend to incriminate me doesn't give me an absolute right not to testify, because I could be mistaken and I certainly could be lying. So the play that comes in here is I say not testifying because it might tend to incriminate me. The prosecutor says, wait a minute, we don't believe there's anything you're going to testify to, at least in the questions we're going to ask, that has anything to do with your being prosecuted later. I say, yes, 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 it does. And what you have then is the judge having to listen to the information from both sides and make a decision as to whether it will be covered by the privilege or not covered by the privilege. Sometimes that's done at a hearing. It's called a castigar hearing. You'll hear, in some of the trials, you'll hear lawyers talk about castigar hearings. That's what they're talking about. They're talking about a hearing where the judge has to decide, are you entitled to claim the privilege, or are you just trying to get some sort of protection that you're not entitled to? You're just like any other witness. We can make you come and testify. The other piece of this is if I say, hey, I've got a Fifth Amendment privilege, I don't have to talk about these things, I am entitled to talk to the judge in camera. That means nobody else there. My lawyer and I, without the state being there, I'm entitled to then tell the judge, here's what I'm going to say, and here's why I think it might tend to incriminate me. That's not information that the state is entitled to know, because if I've got the privilege, the state is not supposed to hear that. So the judge may well have to have a conversation with the witness. That would be Wendi, and her attorney. Right now, that would be John Lauro, to find out whether she's validly claiming the privilege. That's where we get to. Now, we know that Wendi testified in all the trials, and there was a deposition that was taken before the 2019 trial of excuse me, let me not do that twice, of Wendi by Katie Magbanawaz's lawyers. And while we're doing this, we can show slide 2, which is the Fifth Amendment again, up there. And you can see at the bottom, I just gave you the sort of the summary of what the privilege does. So anyway, there was a deposition that the defense wanted to take of Wendi, and it was scheduled, and they held it. A deposition is testimony under oath by someone that can be introduced at trial. Lawyers often use it to find out, hey, what is this witness going to say? I need to be alerted ahead of time. I need to prepare. It's also often used to nail down what the witness is going to say. So when the witness gets on the stand, if she says something different, then the lawyer can hold up the deposition testimony and say, but you said this then, and this is different from what you're saying now. So lawyers frequently use depositions. In Florida, what depositions are used routinely in criminal trials, both the defense and the state have the right to depose the witnesses for the other side. That's not true in federal court. It's not true in a lot of state courts. But in Florida, each side has the right to depose. And in this case, as I say, Catherine Magbanawaz's lawyers wanted to depose Wendi Adelson. Remember, the only entity that can give somebody immunity from prosecution is the state. Defense lawyers are not arms of the state. They cannot give immunity. Now, what I'm going to let you listen to is a clip of a reenactment, dramatic reenactment of a little piece of Wendi Adelson's deposition, because I think it will give you a really good sense of what happens when someone is deposed who has the right to assert a Fifth Amendment privilege, and that person is being deposed by the defense lawyer who cannot give the witness immunity. In this little clip, Tara Kawas and Christopher DeCoste are the lawyers. Tara Kawas was doing the talking, and playing Tara Kawas or reading the part of the deposition of Tara Kawas was Susan from True Lifestyles. The person who's reading John Lauro, which is Wendy's lawyers, he interjects at times, is Joel Waldman from Surviving the Survivor. And the person who is reading Wendi in this reenactment of the deposition is Judy Singh from the YouTube lawyer. And I'm able to use this clip because Judy has graciously let me, so I'm really very appreciative of Judy for letting me do this. And I think this clip, as I say, will give you a feel for how these things will go in a deposition. Now, at trial, this would never occur, because at trial, if the witness has the right to assert the privilege, that witness is not allowed to be called by either side, because, first of all, it would just waste time. Secondly, it might be embarrassing to the witness. And third, it might be prejudicial to the defendant if the prosecutor was allowed to do it. In other words, the prosecutor put Wendi on the stand, for example, didn't want to give her immunity. Now, having said that, let me take another little side tour before I get back to the main point again. Usually, with grants of immunity, the prosecutor has to decide that the testimony of the individual is so important that she's willing to give that witness immunity from use of the testimony or derivative use from the testimony. And I'm going to get into what that means in just a moment. Otherwise, you don't get the immunity. In Florida, however, there's a statute that says if a witness is being subpoenaed by the state to testify, and the witness says, hey, I've got some things that are covered by the privilege, automatically use derivative use attaches. The prosecutor doesn't make a decision about it. The prosecutor doesn't decide, do I want to do it or do I not want to do it? By subpoenaing the witness and putting the witness on the stand, the immunity attaches. So, with all that said, one more comment and then we'll go. What you're going to hear on this little clip is Joel Waldman as John Lauro, Wendy's lawyer, saying, I assert, and then Wendi immediately thereafter saying, I assert. What they're talking about is John Lauro is telling her, don't answer that question. You have the right to assert your Fifth Amendment privilege. And then Wendi asserts the Fifth Amendment privilege. What happened at the very start of this deposition was that Wendi, the first couple of times, said, on the advice of my counsel, I assert my rights under the Fifth Amendment to the U.S. Constitution and to the Florida Constitution. That's the language that you need to use. And John Lauro said, we're going to have a deposition that may go 2 or 3 hours. We don't have to have her say all that language every time. Why don't we both sides agree that every time she says, I assert, we know she means on the advice of my counsel, da 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 da. And that's what they decide. That's what they decide to do. So with all that said, with that preview, let's listen to a little clip from that reenactment of Wendy's deposition. And that will be coming on. And as soon as it comes on, I will let you listen, and I'm going to listen with you.
Stand that?
Yes.
When you first moved out in 2012, did you move to another location in Tallahassee, or did you come down to South Florida?
You can answer that.
I moved to another location in Tallahassee.
Okay. Was this a temporary location? Was your intention eventually to move down to South Florida?
You can answer that question.
No.
How long were you living in this area, in this other address that you moved to?
You can answer that question.
I moved in 2012. I lived there until after Danny's memorial service.
It would be from 2012 until you left Tallahassee. It was the same address?
You can answer that.
Yes.
What was that address?
You can answer that.
3303 Aqua Ridge Way, I think.
I can rely on any of the reports where the officers initially spoke to you and they put your address at that time?
Assert.
I assert.
How far away was that address from Trescott?
You can answer that.
I don't remember, but I'm sure we can use Google and see how many miles apart it was.
Okay, but they weren't you weren't living on the same street. It wasn't close.
You can answer.
It wasn't the same street.
Would you say it would take a 10-minute drive from his house to your house?
You can answer.
That's about what I remember, depending on traffic, maybe 10, 15 minutes.
So you first moved into that address, and this time when you are living at that address, when is it that you filed the paperwork for the divorce?
Assert.
I assert.
Do you know how Dan found out about that? He was being served with divorce papers?
Assert.
I assert.
Did you speak with Dan Markel after he was being served with the divorce papers?
Assert.
I assert.
Do you remember the conversations that you had with Dan about that?
Assert.
I assert.
Do you remember the nature of the conversations? Was Dan upset when he was speaking with you?
Assert.
I assert.
At this time, how involved were your parents in the decision to file for divorce?
Assert.
I assert.
Who are your lawyers at the time of your divorce?
You can answer that.
Different lawyers at different times. My best recollection is that Shannon Novi was my first lawyer.
Was your first lawyer? Okay.
I think.
Okay, that's the clip. I will report to you, having listened to the entire reenactment, that most of it is assert, I assert. The part of that record, that deposition reenactment that I wanted you to hear is where it is that John Lauro is allowing Wendi to answer, and where it is that he's saying, assert your privilege. Notice the pure factual questions. How far was your house after the separation to Dan's house? Anybody could find that out. You can Google it. And of course, that's what Wendi says. You can Google it. She can answer. The question of who were your lawyers during the divorce? Fact, anybody can find out. She can answer it. Questions such as, when that relate to the divorce or the substance of the divorce, anything like that, she's asserting a privilege. I didn't use part of the deposition where she asserts the privilege with regard to any questions about Sigfredo Garcia, any questions once you get up to 2014 and you're getting closer to the time that Dan Markel was shot and killed, she's asserting throughout that. So that's a picture of how that deposition went. And as I say, it's a skewed picture that I gave you because you're getting some answers from her. But in the reenactment of the whole thing, There are chunks when all that it is assert, I assert, assert, I assert. And again, Wendi would never get on the stand without immunity and go through that, because if it's clear that the heart of her testimony is going to be assertion of the privilege, and the other information that she can answer, you can get 1,000 other ways, then she will never be on the stand. Never get there. But I thought you might enjoy it. I loved that reenactment, and I think I must have just kind of a weird brain, because hearing assert, I assert, assert, I assert, I think for most people would wear in a very short amount of time, but I was very amused by it. I mean, I was picturing the lawyers all sitting in the room. Georgia Kappelman is there. She never says anything because she really doesn't have anything to interject. And the time that's just going by where you're hearing this, it's almost a cadence, you know. Would be a bad rap song. So I enjoyed it. I doubt very many people would have the same sort of perverse sense of humor. But if you think you do, and I embrace you if you do, go listen to the full reenactment. Judy Singh has it it's on her channel, and you can pick it up and listen to it. And let me know if you enjoyed it as much as I did. I suspect not, but maybe you have the same sort of sense of humor that I do. So to just get back and to recap a little, for an assertion of immunity, you have to have a credible claim that answering the question might tend to incriminate you. The question has to be asked by the government. The question has to be compelled. Georgia Kappelman subpoenaed Wendi 4 times. There were 4 trials. Wendi testified, and Wendi wouldn't have testified without the immunity. You heard what she said, even in that little clip where she's saying, I assert, I assert, I assert. She doesn't have to do anything but assert unless she gets immunity when she testifies for the state. Okay, so now I want to talk about what derivative use immunity means. And I've got a slide that we're going to pull up to show you, to at least give you some visual picture that you can follow along as I describe it. So again, if you're entitled to claim immunity, the government can, entitled to claim a Fifth Amendment privilege, the government has the right to force you to testify if it can give you immunity. There are 2 kinds of immunity. One is transactional immunity. That means you can never be prosecuted for the crime. So Wendi testifies in the murder trial of Dan Markel, and the charges against the defendants are murder 1, conspiracy to commit murder, solicitation to commit murder. If she's got transactional immunity for those 3 crimes, then the game is over. She can't ever be prosecuted. What is it? Game, set, match. We're all done. Transactional immunity these days is rare. What witnesses typically get is derivative use immunity. So the point of derivative use immunity is that the witness who testifies cannot be put in any worse position than she would have been in had she remained silent and never testified. The other point is she's not entitled to be any better off either. She's entitled to be treated in terms of anything that happens to her in a criminal prosecution as if she had never provided information at all. Can't treat her any worse. Don't have to treat her any better. So let me talk about this a little. I have a number of times on a couple of the other YouTube channels, including Surviving the Survivor and Judy Singh's channel, explain derivative use immunity. And, it's a concept. It's not exactly the most accessible concept And so that's why I thought I would do this video directed at it exclusively to see if, with a little more context, a few more examples, and maybe a lengthier explanation, I could make it clearer exactly what happens. Use immunity means you can never use anything that Wendi says on the stand against her. That's pretty simple. If she had never testified at all, if she was protected by her privilege and remained silent, you would never have heard anything from her. She gets on the stand, even though you've heard something from her, you're not entitled to use it because you've got to treat her even with what would have happened had she never testified at all. That one I think is pretty easy to see. Derivative use says you're not allowed to use anything that you found out from her testimony. In her testimony, for example, she may have said, she didn't, but let's imagine that she may have said, I saw, I was in Miami the week before the murder. And the police, law enforcement, then go track what she was doing in Miami, and they find a witness who says that Wendi was meeting Sigfredo Garcia in Miami. Now, that's pretty damning evidence if the witness is credible. But the law enforcement got that evidence because Wendi said she was in Miami. They didn't know she was in Miami. They wouldn't have ever gone down and investigated or tried to find witnesses as to what she was doing. They only did it because of what she said on the stand. That's derivative use. They're not entitled to use it in a prosecution against her. Now, again, why? Because if she had been silent, if she had protected herself and never testified, never had immunity, you never would have heard her say, I was in Miami the week before the shooting. And if you never heard her say it, you never would have investigated. She's entitled to be in the same place as if she had never given any information at all. And so you can't use it. Now, on the other hand, let's say that she testifies, I was in Miami the week before the murder, but the police, law enforcement had already been doing investigation in Miami and had already discovered the witness who said, I saw Wendi talking to Sigfredo Garcia the week before the murder. The police did not know that she was there, but they were talking to this witness who said she was there. They got that information independent of anything Wendi said on the stand. There was a different way they got to it. It's admissible. If Wendi had never said anything at all, go back to the, where we start, the comparator. If she'd never said anything at all, the police would still, in that hypothetical, have been in Miami interviewing witnesses. They still would have found this witness that said, hey, by the way, I saw Wendi here talking to Sigfredo Garcia. So the fact that she testifies and says it doesn't keep it out because they had an alternative route to that information independent of anything Wendi said. She's not entitled to be any better off because she was on the stand and she never said a word. They still had that independent route. They still would have found that evidence. They still would have been able to use the evidence. So, as I've said many times, the rule is not difficult. The difficulty comes in is how we prove as the state that it really was independent. And, sometimes it's not hard. Sometimes it's pretty difficult. Sometimes it's not possible to do it. But that's where the game is. That's where the Castigar, one of the focuses of a Castigar hearing would be, because witness says, Wendi says, they want to put on this evidence against me in this trial that I was in Miami the week before the murder. And the only reason and they're not going to use my testimony. That would be used. Clear, they can't use that. But the only reason they have that information is because I said I was in Miami and then they did this investigation. It's up to the state to say, we didn't get it that way. We had a different way we got to it. And we're going to call witnesses to show you the route that we took that got us to that evidence, that witness, that testimony that we now want to use, independent of anything Wendi said. The same thing will happen about, other investigations that the state or the law enforcement might do that don't involve Wendi being somewhere. It might be another witness who comes forward with information, but the only reason why the police knew that witness was there was because of something Wendi said. You got to show an independent way to the information. Now, there's more to this than what I just did, but certainly for purposes of what might happen when Wendi is prosecuted, this is more than enough, I think, for you to be able to track if there is a Castigar hearing, what in the world they're arguing about, and to make your own independent assessment of whether you believe the state saying we got it a different way. No. At a Castigar hearing, it's up to the state to demonstrate the independent source. The defense only has to say, hey, I testified, I said this, they found the witness, then the defense is done. It's the state's burden to then show that it was independent. The burden is not proof beyond a reasonable doubt. That's the burden at a criminal trial to convict, but it's still the state's burden. And if there's any question, the judge is likely to lean on the side of Wendi, because the privilege against self-incrimination is a huge constitutional protection, and the judge is going to be very careful to protect the person asserting the privilege from any risk that the privilege has been breached, and that the state is going to be able to use testimony that the state got because of what Wendi said on the stand. So I want to now talk about a couple of other things that come up. One is I've seen comments over time by people in various chats saying, we know all this other evidence, and we know it because there have been podcasts that have found out some of it. There have been documents that have been posted on the dockets of the various trials. There have been people who have been interviewed by, the legacy media, all those things. So we know this happened. We know this happened. We know that happened. Why didn't Georgia ask her about these things? Well, there's a really easy answer to that question, and it's called the doctrine of the immunity bath. And I really thought about trying to find a slide for you with somebody in a bathtub, but I couldn't find anything that was tasteful that even came close to getting at what I'm going to be talking about. So you can imagine somebody in the bathtub while I'm talking, and you can be as untasteful as you want because nobody's going to see it. There are no YouTube rules that will prevent it. So, but keep this picture in mind if you want to. Georgia Cappleman wants to prosecute Wendi. And you recall she said that after, I guess it was Charlie's trial. And she was overheard on an open mic saying it. She would never have said it otherwise, but she was overheard and was played all over the place. Wendi. Most people watching the trials, watching Georgia Cappleman's behavior, listening to Wendi, who, this is a side comment, who was a terrible witness, felt that Georgia Cappleman would like to prosecute Wendi for the crimes. So let's assume that that's true. She wants to preserve as much as possible her opportunity in a prosecution against Wendi. Wendi's got use immunity. Wendi's got derivative use immunity. The last thing she should do is ask more questions and get more answers than she needs or thinks she needs to prosecute prosecute the defendant who's on the stand when Wendi testifies. Because anything else that Wendi says, Georgia can't use. And then you're back to the derivative use issue. It may be fairly, what Wendi says may be fairly innocuous, but it may provide an investigative lead. And now Georgia may have the problem of showing, hey, we would have gotten to this independent of what Wendi said. Why buy that extra problem if you don't need Wendi's answer to a particular question? So any prudent prosecutor, and certainly Georgia Cappleman is a prudent prosecutor, is not going to ask more questions than she absolutely needs when Wendi is on the stand. There's another aspect of this, and that is when you've got a witness who has derivative use immunity, the very last thing that you ever want to do is to ask an open-ended question. And this is going to lead me directly to the immunity bath. So let me, and there were people every time that I've done this, who follow it really clearly, very bright. And then they say, well, I know what I would do if I got derivative use immunity. I'd get on the stand and I would testify to every single thing I ever did in my life that might lead to a criminal prosecution because I've got this bath. You can't use it. You can't use anything derived from it. I'm going to go whole hog and get myself protection all over the place. If the law allowed you to do it, the law would not be very smart. In Oliver Twist, Charles Dickens' Oliver Twist, there's a character, Mr. Bumble, and I love this quote. Mr. Bumble says, if the law supposes that, then the law is an ass. The law, at least in this situation, is not an ass. I would never be heard to say that the law is never an ass. In fact, if I said that, I would be the ass because, the law is not perfect. Nothing else is either, but the law is not perfect. But the law is not an ass in this situation because the rule for a witness who's got derivative use immunity is, we know the witness has to testify truthfully. That's a given. Testify fully. That's a given. But the witness has to answer questions and be responsive to the question. The witness is not entitled to go on a frolic and detour and then say, I've got immunity from that too. So let me give you an example. Prosecutor is prosecuting someone's brother for murder, and she's called to testify. And the prosecutor says, where were you on April 5th at 8 a.m.? And the witness says, well, on April 5th at 8 a.m., I was in my house hiding the evidence of the 2 murders I committed last week. Now, the hiding the evidence of the 2 murders I committed last week is not responsive to a question that says, where were you on April 5th? That's all the question said, where were you? What would be responsive to that question is in the house. The extra stuff is not responsive. And if the witness does that, she's likely not covered by immunity because she went on that frolic and she tried to pull a fast one on the government and get herself more protection. Not going to happen. On the other hand, let's say what the prosecutor asked was, what were you doing at 8 a.m. on April 5th? And then the witness says, well, on 8 a.m. on April 5th, I was in my house hiding the evidence of of 2 murders last week. That's responsive to the question. She's going to get immunity for it. It's the prosecutor's problem for asking that question in a way that allows that witness to get immunity for something the prosecutor never in her wildest dreams was going to come up. So prosecutors have to be careful not to ask for more information than they need and never to ask open-ended questions, because otherwise we're into the world of immunity bath. So now you can get out of the bath, you can dry yourself off, because I want to talk about another issue that comes up with regard to grants of use, derivative use immunity. And that is what happens to the defendant who's being prosecuted when a witness testifies under a grant of use, derivative use immunity. The defendant has a Sixth Amendment right to a fair trial. The defendant is entitled, as a matter of Sixth Amendment protection, to confront the witnesses against him. Fair trial means you have the right to put on all evidence that's going to help exculpate you, unless there's an evidence rule. Hearsay can't get in, but the evidence rules aside, you have a right to get all that evidence in, and you're not supposed to be limited in what you can do that affects that right. But on the other hand, there's a witness at your trial who's got use, derivative use immunity, and she's got a constitutional right too. So you've got, in a way, two constitutional rights butting heads. You've got the witness's Fifth Amendment protection, and you've got the defendant's Sixth Amendment right to a fair trial. So how do we work this out? Well, one, it works out sliding towards the witness who's got the immunity. I think any defense lawyer who's ever been in this situation would say that's the case. But what is allowed is the defense lawyer is entitled to cross-examine the witness with the immunity, but only to ask questions within the scope of the direct examination. So Wendy's on the stand. Georgia Kappelman doesn't ask her. Wendy's on the stand, let's say, and Katie McBanoa is being prosecuted. Now remember, Katie McBanoa is the go-between in the middle between the Adelsons, who paid for the killing of Dan Markel, and the people on the other end who did the killing. Katie is the connection between the two. So her lawyers want information from Wendi about what she knows about what Charlie and Donna were doing that would tend to help Katie and maybe incriminate Donna and Charlie. And remember, right now we're at Sigfredo's trial. Georgia Kappelman doesn't ask any questions on direct examination about her relationship with Charlie, her relationship with Donna, her interaction with Katie McBanoa. Now, not going to happen because, as we know, the reason why she's on the stand is to provide information, at least some information. But to make the hypothetical clear, no questions. The defense lawyer is not entitled to go into those areas because it was not in the scope of direct examination. Were the defense lawyer be in the position of doing it, and you see Katie on the stand with her, with her jail garb on, she's testifying at another trial. Were the defense be able to do it, it would be the same as if the defense was entitled to subpoena Wendi in the first place and ask those questions. And we know that the defense lawyer doesn't have the right to subpoena because the defense lawyer cannot give immunity. Well, you can't get in the back door by not subpoenaing, but waiting until the prosecution asks the questions and then try to get the questions in that you're not entitled to ask because they were not the subject of the direct examination. Can't do it. Everybody has to be wary about it. Georgia Kappelman has to be paying attention to what the defense lawyer is trying to ask and stop it. And Wendi should be careful about it also. The judge should be careful about it. They may have vetted this, on the front end before it ever came up, but the defense lawyers are not entitled to do it. They are entitled to go after as deeply as they want any evidence related to what Wendi actually testified about on direct examination. So that's the defense lawyer situation. It's probably not a happy situation for a defense lawyer. The defense lawyer would like to do a better job. There may be things that the defense lawyer believes absolutely that Wendi can provide that would help his client. Can't do it. Now, if you remember, I'm sure you remember the assert, I assert, that little clip reenactment. The defense lawyer don't object to or put on the record anything objecting to Wendi's asserting. And they have a right to say, hey, you're asserting to things that are not covered by the privilege. And in that deposition, they may have gone to the judge ahead of time and gotten, areas that they knew were off limits. They may have had an agreement with John Lauro, and that's why it didn't happen. At Donna's trial, Donna Adelson's trial, and I know many of you watched at least parts, if not the whole trial, the defense lawyers there tried to be able to ask some questions of Wendi on the stand. There was a hearing about it, and they said, hey, these are not covered by anything she's got a Fifth Amendment privilege about. We're entitled to go into them. They're relevant to our defense. Our defendant, Donna, has a Sixth Amendment right. We need to be able to go into them. And the judge said, well, and defense lawyers agreed, at the first trial, the trial of Sigfredo Garcia and Katie McBanoa, defense made the same argument, and the judge ruled, it's not, I understand, I'm sympathetic, but this comes within the privilege, you can't do it. And that's what happened at Donna's trial. And you can go back if you want to and find that hearing. The defense lawyers made quite a point of it. They tried to persuade the judge. They wanted to say, hey, we'll even give you the questions so you can see they don't relate. And I apologize for this. I don't recall what the precise resolution of it was. I think, however, that the judge said, hey, if you got a couple of questions that you want to ask, and, when you get there, you want to argue it, we can talk about, and I'm willing to consider it. But the likelihood that he would have said it's okay and you can do it was not very high. So the situation for a defense lawyer, as I say, is not a particularly happy one in this situation. But in fact, when you've got a fight of two constitutional rights, there's never going to be a resolution that is absolute and happy with one right, because you've got a conflicting constitutional interest on the other side. So you get a result that isn't the complete articulation of the right on either side. Same thing, by the way, happens with fair trial, free press. Same thing, same sort of thing. Two constitutional rights head to head. They can't both have their full articulation. You've got to come to a reasonable compromise that protects the heart of each constitutional right, but you don't get, the periphery around the heart. You don't get the fat around the heart on either. Oh God, that was a bad analogy. But I have you in bathtubs, and now I give you that sort of analogy, but you can put that one aside, or maybe wash it in the bathtub now. So let me go on. I don't want to pursue this anymore. Let me go on to another aspect of the privilege against self-incrimination and the derivative use immunity. As I said a moment ago, the deal is that the witness who has the immunity is going to testify truthfully and is going to testify completely. What if that witness gets on the stand and seems to have lied? Well, a perjury prosecution is always available. Perjury is not something that a defendant with a witness with use derivative use immunity can avoid if she lies on the stand. Now, there are a lot of qualifications here. In order, and there are different definitions of perjury in, some of the states, but in Florida, and I'm talking about Florida only, perjury when you're on the witness stand has 3 elements. The statement has to be false in fact. The witness has to believe it's false when she provides the statement, and the statement has to be material. So 3 elements to it. We know, anybody who's paid attention to this case over the years knows that Donna has made contradictory statements on the stand, and certainly contradictory to what she said in Detective Isom's interview of her on the day of the shooting. And let me just mention one that I know we all know is her varying stories of when she drove from her house on the day of the shooting to get to her luncheon with her friends, and she drove out of her way and then turned or didn't turn on the street leading to Dan Markel's house. We know she said all kinds of things, that she didn't turn, that she turned and made a U-turn, that she didn't go very far, that she was far enough to see the police cruiser. Contradictory, no question. But are they false for purposes of the perjury statute? Well, part of the issue here is the way Donna testifies. And again, those of you who have heard her at trial know very well, and we now have slide 4 up with regard to perjury. Those of you who have heard her at trial know very well that she doesn't say yes or no, it was, I did. Done a little better in Donna's trial, but she says, I think, I believe, that sounds right. Well, if it's in the transcript, I'm going to say it's in the transcript. It might be true. Well, none of those qualifiers equal a direct statement of something false. If she were to say, I talked to my mother the day of the shooting, that's a statement of fact. And then if she says at another time, I did not talk to my mother on the day of the shooting, you've got 2 unequivocal statements, and they disagree with each other. So you can then get to the second element. Did she believe that one or the other was false? But in her case, she would say, I think maybe I talked to my mother the day of the shooting. That's a much harder statement to say, gee, she perjured herself. And she does a lot of that. So for a perjury prosecution for Wendi, the way she testifies makes it more difficult to have a perjury prosecution. Then the second question is, did she believe it was false when she said it? You've got to be able to prove that. That's not always easy to do. The third element is, was the statement material in the prosecution that she was being prosecuted for? Material means, is it something that from which, or there's a building block in making a showing of guilt beyond a reasonable doubt? It doesn't have to be a big building block. It can be a tiny, tiny building block, but it has to be something that leads you on the road to a conviction. Now, let me give you an example of that hopefully will make it clear what we're talking about here. You allegedly paid for a murder. You were not at the scene. You were not the one who pulled the trigger. There are no eyewitnesses to anything at the murder scene. You have brown eyes. In one of the trials at which you testified under a grant of derivative use immunity, you said unequivocally, I have blue eyes. The statement was false. Clearly, you have to know what color your eyes are, unless you're colorblind, and then I don't even think that would matter. But in any event, You have to know what your eyes are. So you've got the first two elements of perjury nailed. But the third element is it's material. In that prosecution, what does the color of the witness's eyes have to do with any element of the crime that's being charged against the defendant who's being prosecuted? Nothing. That's clearly a lie, a knowing lie that cannot and would not constitute perjury in Florida or in any other state of the union or in a federal prosecution. All perjury statutes have a materiality element to it, in part because people lie on the stand, and it may have nothing to do with the elements of the crime. You witnessed a murder, but the reason why you were in a position to witness a murder is you're married, but you were having an affair with someone, and you with that someone at the time in a hotel room. You don't want to say that's how it was that you were able to witness the crime. And so you make up some story. It's a lie on the stand, but it's not material to anything. It has nothing to do with the murder at all. It may call into question how, whether you really were in a position to witness it, but you could say you were in a hotel room by yourself. The lie would be that you weren't. Not material. That lie is not material. You wouldn't be prosecuted for perjury based on the lie. So perjury it has to be false. You have to believe it's false. It has to be material to the prosecution before you can be prosecuted for perjury in Florida. And as I say, with Wendi, the first element, it has to be false. Given the way she testifies, is not an easy element to get to and to be able to demonstrate to the satisfaction of the jury. And remember, criminal prosecution, perjury is a crime. The state has to prove all three elements beyond a reasonable doubt. So if the jury is looking at this with one of Wendi's, I think it might be, if that's what the transcript says, I'm not sure I remember, but ask yourself how easy it would be for you to say beyond a reasonable doubt she was telling a false statement and knew it. Not easy. So I don't see a perjury prosecution in Wendi's future. I think if she's prosecuted at all, it's going to be for the same crimes that Sigfredo Garcia and Catherine Magbanua were prosecuted for, that Luis Rivera pled to, that Katie's brother, Charlie Adelson, was convicted of, Wendi's mother, Donald Adelson, was convicted of, that Wendi's brother, Charlie Adelson, was convicted of. It's going to be murder one, conspiracy to commit murder one, and solicitation of murder one. So I have one other issue I want to get to with regard to derivative use immunity. And this one, I'm going to say at the outset, is one that I cannot tell you with certainty how it works. Let me tell you what it is, and then I'll tell you why. I just don't know. Clearly, derivative use immunity covers you from being your testimony being used, the actual testimony being used against you in a later prosecution. Substantive use. You said this, and you said it, you claimed that it happened this way, and we're going to use it against you in a prosecution as evidence that what you said you did. Substantive evidence. Impeachment use is something different. And I know you hear, at trial, in trials, you're always hearing about, we're going to impeach, we're going to impeach, we're going to impeach. What impeachment means is you said A on one occasion, and you said negative A on another occasion. Both A and negative A can't both be true. So one of the times you were lying. You're on the stand, and on the stand you say negative A, And I have in my folder a deposition from you where the answer to that same question, you said A, positive A. You say negative A on the stand, and I now say, well, on such and such a date when you were under oath, didn't you say positive A? I'm not using it for, you hear this a lot too, I'm not using it for the truth of the matter stated. In other words, I'm not saying you said positive A in the deposition, holding it out as the truth. I know that one of the statements is true and one is false. I'm not claiming that the impeachment use statement is the one that's true. If I were claiming it was true, then it would be substantive evidence. Not doing it. That's not what impeachment use is. I'm just using it to say you lied either then or you're lying now, and the jury should take into account that you're a liar when it listens to anything you say about any subject that you're testifying to. That's impeachment use. So Wendi testifies in all those trials, and now we want to impeach her. Now, impeachment use doesn't require, the way perjury does, that we have to show that it was a false statement of fact, because we don't know which one was. We don't have to show that it's material, because what we're trying to show is the witness is a liar one time or another. The jury may say, well, whether he had blue eyes or brown eyes is so insignificant, we're not going to hold that against the witness. We're not going to say because he said blue eyes once, brown eyes another time, that now we should doubt everything he says. The husband who is having the liaison with the girlfriend and testifies that he saw the murder, and now and he saw it because he was in a hotel room by himself, and now he's being impeached because it isn't true that he was in a hotel room by himself. The jury may well say, oh yeah, he lied, but that doesn't mean he's a liar. You know, this is something that people do. We may take it into account, but we're not going to hold it against him when he tells us about what happened, what he saw, particularly if what he says about what he saw, the murder, is credible, and especially if it's corroborated by other evidence. We're not going to hold it against him that he lied. Yeah, he lied, but it's not going to be a big deal for us. So that happens with impeachment use. But the point is, it's being used to say, one time or another, this witness lied, and jury, take it into account. We can't tell you how much to rely on it, but we can tell you she lied, take it into account. So, let me see. I had another example that I think that should be clear enough. If you've got questions about it, you can always email me at askprofjoe@gmail.com, and I'll try to respond. And I should say here that if there are questions about what I'm doing, or there are areas that I've done that you really want a deeper dive in, and you send to askprofjoe@gmail.com, or get to me through YouTube, generally at my YouTube channel, Prof. Joe Explains. If there are enough people who are having a question, or there's an area that they really want to know more about, I would be happy to put together an episode to do it, because I want to respond to what you're interested in. And I certainly want to respond to questions, in part because I think that makes me a better presenter and a more helpful person, but also because it's good for me, because you may be thinking of questions I wouldn't have asked myself. I didn't even think about them. So it's energizing for me to hear alternative views and be able to pursue them. So if there's anything here and you want me to do more, just let me know. So I'm not going to do that other hypothetical, because at least in my mind, what I've said so far is probably clear enough, but I'm certainly willing to be disabused of my impression about it all. But now let's talk about Wendi. I've said, and that a lot of her statements are such that it would be hard to really nail her down. You can use them, and maybe they'd be effective, but probably maybe not a lot of them that would be effective. All the different ways she said she turned on Trescott Drive, that might be helpful. Okay, so we're thinking that might be helpful. She has derivative use immunity. One of her obligations is to testify truthfully. And we're saying with all these different stories, she wasn't testifying truthfully under oath at the 4 trials. Let's stick with the trials where she's under oath each time. Okay. So we think, hey, her deal was she was going to testify truthfully. We say to any witness who gets on the stand, you lie under oath. We can go after you for a perjury charge. We can certainly impeach you. She's got an obligation to testify truthfully. That was her deal. That's why the state said we won't use anything you say against you. And she's breached this contract. So we should be able to use it. And I will say every witness has the obligation to testify truthfully. It doesn't matter whether they've got derivative use immunity or not. Somebody with that immunity has made a deal, has a contract to testify truthfully, and has an obligation to testify truthfully. And you breached that agreement. So impeachment use should be available. Nobody should have a protection from lying on the witness stand. And that's a general rule of law. It's not something, directed at somebody with immunity. Nobody should have the protection of lying on the stand. Every trial lawyer that I have talked to about this, the question I'm talking about now, has said, well, of course you can impeach. Of course you can impeach. Of course you can impeach. And what I'm telling you now is, I've looked at the case law on this, and I think the answer is no, you can't impeach. Not clear, but it's certainly an answer that tends to say you cannot use what that witness said under a grant of derivative use immunity, even when she lies at a prosecution for a crime, even if all you want to use it for is she lied here or she lied there. You don't need to trust her. It sounds wrong. It sounds wrong to me. It sounds wrong, but that's where it looks like the law is. Now, if there's any lawyer in this chat who knows better, who knows a case that's clear on it, please let me know. Send me that, at AskProfJoe at gmail.com. I would love to know, but I think the answer is no, you can't do it. And I don't think there's anything definitive that says you can. Now, let me tell you why there's nothing definitive. And this is easier for me. This is clear as to why you can't grab the answer. It's like pulling water. First, witnesses under grants of immunity testify truthfully. You don't get a lot of them who get on the stand under a grant of immunity and then lie. So that's one reason. Probably not a big one, but it's one reason. But it narrows your world. So out of the world in which a court is going to talk about this, we've now excluded everybody but those who might have lied. And it's taking out so we got a smaller world now. Then even witnesses who've been given derivative use immunity and therefore can be prosecuted, most of the time are not prosecuted. So our world of those who might have lied in their testimony, who will be prosecuted, we're getting a smaller world. Then we get to the big, let me get to 3 first and then get to the real biggie. And that is, if the law is not entirely clear on this, and the law is not entirely clear on this, at least so far as what I found, if you're the prosecutor in the prosecution of this person who had the derivative use immunity in a prior prosecution of someone else, and you don't have clear law, you're not going to impeach. You're not going to risk losing a conviction because of clear error by impeaching when that witness has a constitutional right not to have it used even for impeachment. So you're just not going to go there unless it's the only way you think that you can get a conviction. That's very unlikely, in my opinion, because if your evidence at that trial is so shaky that you need to say, hey, this person on the stand testified before, she was either a liar, she was a liar sometime or other, that's not a prosecution you're going to bring anyway. All that aside, the really big reason why it doesn't happen is she's not going to testify in the trial when she's being prosecuted. Defendants generally don't testify when they're being prosecuted. Everybody thought Donna Adelson was going to get on the stand and testify that she thought she could talk her way out of anything in the world. Everybody said she's going to do it, she's going to do it, she's going to do it, and she didn't do it. So the number of defendants generally who testify at their own trials is a small number. And in this situation, so you've got this little world anyway, and then you have to assume that the witness will testify, because you can't do impeachment use unless the person who's made these conflicting statements is on the stand. You've got to get the conflicting statements you impeach by talking to the witness. If they don't get on the stand, you can't do it through impeachment. So all those reasons together mean whatever the law is, the case law is that would give you the answer just doesn't come up. And so there isn't a clear answer. And again, since there's not a clear answer, we're not going to get a clear answer, because a prosecutor who does prosecute this previously immunized witness, now a defendant, is not going to risk her prosecution by impeaching, and then we would get a clear answer. But if she's wrong, she's going to have a reversal of conviction on appeal and is going to have to retry. So it's just not going to happen. But as I say, I'm really sorry to tell you that I can't give you a yes or no answer to it. What I am willing to say on the record emphatically is if there's a prosecution against Wendi, she will not testify. And I say that not simply because defendants don't generally testify. It's because by this time, she has to know what a bad witness she is. The jurors who've been interviewed with regard to Wendi in the, I don't know whether it was the first or second trial, and then I think one from Charlie's trial, and there were 3 this time from Donna's trial, have said they don't believe her, have said there's enough evidence to convict her. As I said earlier, she's a better witness than she was. And anybody who wonders about that, go pull up her testimony from the first trial when she's being questioned by Georgia Kappelman, and you get all these equivocations and all this, did you mean this? And listen to her in this last trial. She's much better, but she's still not good. She's just not believable. So she will not get on the stand. So we're not going to have to worry about impeachment use or not, because it's just not coming up in her trial. And so anyway, that's what I would say is the whole enchilada, at least as I know the enchilada with regard to derivative use immunity. And I hope it was helpful. I'm now going to pull up a last slide here. I think it's numbered slide 5, but it's the last slide, because I want to sum up what we've just talked about. And I thought being able to see it might be helpful as I say it. So 1, the evidence from anything that Wendi said when she was interviewed by Detective Isom the day of the shooting, any other statement she made prior to her testimony on the stand, any statement she makes after her testimony on the stand, so long as they're voluntary, not compelled by anybody, are perfectly open to the prosecutor to use. Emails that she sent prior to, contemporaneous with, afterwards, voluntary, no problem. Her book, voluntary, no problem. If she writes another book today, voluntary again, no problem. Anything that's voluntary, no problem. Anything that she's got the derivative use immunity, well, let's say use. Anything she testified to on the stand can't be used. anything derived from, when it was derived from that testimony, and it was the only way that the state was able to get the evidence, can't use. Can't use. But the issue will be, did it really derive from? Was it independent? And you'll have a Castigar here. If this ever comes up, there'll be a Castigar hearing to try to decide whether it can be used in evidence or not. And as I said before, I don't see anything that she testified to that's going to be a problem with derivative use immunity. That's not to say that the defense won't scream and yell about it. It's not to say that there won't be a Castigar hearing about it. I just don't think it's going to be an impediment to Georgia Kaupelman prosecuting a case against Wendi. Just don't see it. And Wendi is not, as I said, Wendi will not testify at her trial. There's not going to be a perjury conviction against her. That's not going to happen. So I think that's really everything that I want to say here. Again, you can, if you've got questions, you can send me something at askprofjoe@gmail.com. And again, I would love it if you would subscribe to this channel. I would like to be able to do more interactive and be able to get a live conversation going, even though it's coming through a chat as compared to talking. But there have to be enough subscribers to make that possible. So subscribing is free, doesn't cost you anything. And so it doesn't cost you anything and would help me. So if you would consider it, I would really appreciate it. So to end with, I'm going to say ciao. I told you at the beginning that ciao in Italian means hello and hi. Well, odd, but it also means so long, goodbye. So it works on both ends. You just have to know on what end of the interaction you are to know whether it's a hi or a goodbye. Obviously, this one is a goodbye. I enjoyed doing this presentation. So long.